Good afternoon. We have a big crowd. I won't take too much of your time. Whistle-stop tour. Thank you, folks. Whistle-stop tour of GDPR, or the General Data Protection Regulation, which many of you may know or not. There's been a lot of noise about over the last year or so. It's an overhaul of welcome. It's an overhaul of the data protection regime that exists currently in Europe, and will come into force next year, May 2018. This afternoon, I'll just talk about a few things: what's driving all of this, who are the key players, and why now, and what took so long in light of the fact that the existing regime has been around since 1995 and hasn't been changed in that time, 22 years or so. In fact, as we stand here today, GDPR actually is in play. The regulation exists. It's not actually going to be enforced until next May 2018. So that gives you 8 months or so to get your ducks in order. The first question arises: is this a radical overhaul? Well, it isn't actually really a radical overhaul. In fact, many of the principles and concepts that exist today under current data protection legislation actually remain. What it is a set of clarifications and some enhancements. But fundamentally, it's there to achieve the same purpose, which is to guarantee the fundamental right to privacy of European citizens. Why now, you may ask? Well, 1995 was the initial regime, and it was a directive issued by the European Commission, and each member state legislated for it on their own terms. And what we ended up with is actually a patchwork of legislation across Europe, which creates all sorts of practical difficulties for organisations on the basis that each interpreted the directive in their own way. Some maybe take a more firm view than others. But ultimately, back in '95, it was a different world. Obviously, it was the emerging of the digital age. With the emerging of the digital age back then, it's completely entirely different now. And I heard some speakers earlier today talking about things like the cloud and iCloud, and the way we consume data, the way we store data, the way we interact with goods and services is completely different. So ultimately, what they're trying to do here is give some consistency, transparency, and ultimately set the bar the same across all the EU member states. And it comes back to the fundamental base for this is to guarantee the right to privacy for European citizens. Just some of the main implications of GDPR itself, and some of these enhancements I mentioned. The biggest one, and the one that's getting most attention, is actually sanctions. So previously, or as we stand here today, in fact, there's very little opportunity for national authorities to fine wrongdoers. And just to give you one example, Talk, a UK company that had a data security breach at some stage last year, where the records of their clients were released, were ultimately fined £400,000 by the national authority in the UK. Under GDPR, that fine could have been as high as I think £70 million. Another example would be a recent breach in Equifax, you may have heard of in the news. It's a US organization which provides credit checking services. They provide that into the UK market, and as a result would have all sorts of data relating to UK citizens. Their breach was revealed recently, and it took them 40 days, I believe, before it was actually announced. And ultimately, there is no opportunity to sanction that particular organisation. It exists as a legal entity in the US. Although it does process data of EU citizens, the GDPR will change that fundamentally on the basis that an organisation, regardless of where its operations are, if it stores or processes data in relation to EU citizens, it must comply to the rules of GDPR. But to give you an example, as far as I understand, Equifax is in and around a global revenue of 3 billion, so 4% of that global turnover would be substantial, obviously. I don't know how much, 100 million or so plus, but ultimately that's certainly getting a lot of attention in the boardrooms around the world where organisations do store or process data relating to European citizens. Another question arises in relation to mandatory DPO. In fact, some countries in the EU already require a mandatory data protection officer, for example, Germany. However, it will be mandatory for certain kinds of organisations that process large volumes of data, in particular organisations that would process what's known as sensitive personal information. That could be health information, religious beliefs, and so on. But ultimately, many organisations now will need to appoint an internal data protection officer who will ultimately provide governance and oversight. Another idea of privacy by design, which is an enhanced requirement, ultimately where, and I think this means compliance isn't a particular stage of the point, and it may be a point in time. To maintain ongoing compliance, it really be on a project-by-project basis. So a risk assessment will need to be done of any given project to understand to what extent personal data is involved, the risks to that personal data, and so on, and the controls that one must implement to guarantee the safety and security of that data within that particular business process. So ultimately, privacy by design will be baked into business processes that may arise in the future. And as you can imagine, as organisations, I mean, many of the organisations in the room here will get up to all sorts of things, from joint ventures, mergers and acquisitions, and so on and so forth, all sorts of new products being established all the time. And each one of those scenarios will need to be scrutinised from the point of view of GDPR. Previously, you could rely on the consent of the individual to process their data, and that becomes a little bit less, or you can rely a little bit less now on consent alone. There must be a legal basis for the processing activity you undertake, and the individual must very explicitly agree to opt in. And then the organisation must only use that data as you've agreed with the data subject. They can also request, in fact, that their data be deleted, which is the right to be forgotten. You may have heard of in the media, and other scenarios which ultimately put control back into the data subject or the private citizens' hands. Another substantial enhancement is breach notification. So there'll be mandatory brief notification, which didn't previously exist, at least for all organisations. Will come about next year, and to make matters more challenging, an organisation will have 72 hours to inform a regulator that a breach may have taken place and that there may be private data at risk. That creates all sorts of challenges internally in organisations. They must ultimately have processes, procedures that allow them to ultimately manage incidents. And I believe that if there's a failure to report a breach, that can result in a fine on its own, which will be entirely separate from a fine for the breach itself. So ultimately, organisations will have to notify both what's called their lead supervisory authority within 72 hours, and then most likely will need to notify the individuals who are impacted by the breach itself. Territorial scope has changed. I mentioned earlier, it doesn't matter where you are. If you are processing data that relates to EU citizens, GDPR applies, and this ultimately gives European authorities very far reach in terms of fines and sanctions. And I mentioned the Equifax incident earlier on. That's a good example of an organisation that exists as a legal entity in the US but processes data relating to the EU individuals. In this scenario, the European authorities would have a path to interact and ultimately fine that organisation. Another thing I think is, again, the organisations in this room and supply chains are very complicated. Many organisations will outsource a variety of business functions, business processes, and so on. Ultimately, there will be a concept of dual liability whereby that processor will have to take some of the heat in the event of something going wrong, and they'll have to be able to demonstrate that they're compliant in the same way. It doesn't necessarily mean you're outsourcing your legal obligation. The law is the law and you must comply. But there will need to be far more consultation between an organisation and its third-party providers, suppliers, and so on, right down the supply chain. And in fact, there'll be sub-processors and sub-processors and so on. And it can become quite complicated. And over time, organisations will have to deal with that and perform correct due diligence exercises on these third parties and their partners. Right to erasure, I mentioned. Individuals will have the ability to request that their data is deleted, and in fact, purely from a technical point of view, actually that creates all sorts of challenges within organisations. Whatever about what you might call structured data in databases where you can search it and find it and remove things. Data exists in unstructured data sets, whether it's email or stored in the cloud in unstructured form. It becomes very, very difficult just technically from a technological point of view to find and remove specific data relating to certain individuals. Another interesting area, I think, will be the idea of collective and individual redress. So previously, where an individual is impacted, they had very little opportunity, for example, to sue an organisation that was reckless with their data. That changes now next year under GDPR, and I think this will create difficulties for organisations and opportunities for individuals, and could become a little industry in itself, and I would suggest to watch that space. Finally, a quick word on data portability. So individuals will have the ability to request their data from an organisation, and on that basis the organisation must be in a position to somehow package it up into a set of documents and transmit it in a safe and secure way to the individual making that request. And that again requires organisations to revisit business processes, procedures, and technologies and technological infrastructures to ultimately figure out whether they'll have the ability to physically hand somebody a data set if it's requested. So a couple of things you can do. Obviously, time is approaching. I think that this is getting reasonably high level attention, most probably because of the sanctions issue in organisations where board level interest does appear to be to exist. But now's the time. Ultimately, there are projects ongoing all over the world, but it's not easy. Ultimately, it's about mapping business processes, understanding the flow of data, understanding where it's stored, understanding how to put your hand to it if you need to find it when you need to search for it, to get rid of it when you need to get rid of it, to set appropriate retention policies and so on that data. And that all is quite a challenge, although you would expect, given there are existing data protection laws in place, that many organisations will at least have gone some way towards compliance. As I mentioned, it's very much an education exercise. Ultimately, anybody who interacts with personally identifiable information will need to understand their obligations. At the point of collection, there now needs to be very clear opt-ins from the individuals providing that data. You need to keep it for as long as you need and very much set clear. There are technological solutions whereby you can set clear retention policies on data to expire it after a certain amount of time and so on. But there's a whole range of activities that organisations are ultimately undertaking at the moment. I'll just point to one, which is encryption. And I mentioned the breach notification, 72 hours and so on. And this is really only in the event that you believe that there's a risk to the individuals on the basis of a breach or misuse of their personal data. If that data, for example, is encrypted, all that kind of goes away because there is no risk, assuming that you're using appropriate encryption technology with appropriate strength encryption. ultimately a lot of that falls away. So I think GDPR on its own will start to drive the use of a lot more encryption in the design phase of new products and services and technologies. Data breach, I mean, how do you know? And I think it's interesting, if you suspect a breach, that's the point in time at which you must inform your a national authority. You might necessarily, and there's various specific bits of information you must provide, but often in a breach scenario you don't know, because it's an active investigation and you're trying to figure out what happened. And the question arises, well, I think I might have a breach. I'm not sure of the impact. I'm not sure how many people data is lost. I'm not sure about much really, and we have all people looking into it. Nonetheless, at that point, you must inform the regulator, and you can then provide further updates on a phased basis, and they're okay with that. But I think the important thing here is to ultimately lower the likelihood of any kind of fine or sanction is to initiate that dialogue early where possible, and be open and transparent. Ultimately, there will be often as well an obligation to set up some kind of mechanism whereby you inform individuals themselves, and provide them with as much detail as you can. And as I mentioned, encryption will remove many of these challenges. An awful lot, I think in terms of sanctions and in terms of conversations with data protection authorities, a lot of it will come down to being able to demonstrate that you took reasonable care, that you have processes, that you've trained people, that people are educated, and that all that obviously then on that basis needs to be documented. And the more that you can demonstrate, the less likely you are to suffer any serious consequences in the event of something going wrong. And in fairness, through the best will in the world, things go wrong, systems get breached, people make mistakes, people lose things, and so on and so forth. But if you can demonstrate that, well, okay, we reduced the likelihood insofar as it was possible of that happening, the chances are the conversations with any given data protection authority will go a whole lot better. And on that basis, right from the point of where you collect data from individuals right through to where it's expired, as per some retention policy, if all that's documented and well managed in some, for example, privacy management system, that will go a long way in helping you have a much easier conversation if you find yourself in that position. Sanctions certainly will motivate. My experience from consulting with large global organizations in this issue is that boards are interested. There are governance models being set up. Nobody wants to be the first, and somebody will be the first, and the fines will be heavy where an organization is found to be negligent. So the more you can do to minimize the chance of that happening, the better. Couple of final words and standards. This being from BSI, and when we ultimately build standards in and around this space. There's an interesting standard which is actually currently a British standard, BS. It's actually BS, not BSI, but BS 10012 is a personal information management system, and that's recently in April of this year been updated to reflect the requirements of GDPR, and that's currently the only certifiable standard in the world that exists. And is most likely going to turn into an ISO standard over the next 12-18 months, and that conversation's already underway. There is another one, ISO 29101, which ultimately is a privacy architecture framework, which is useful if you want to benchmark an organization and the activities it undertakes against best practice in the area of privacy. And ISO 22307 deals specifically with privacy impact assessments, and in fact, ultimately, this is going to be an activity that you'll see more and more of, and projects get established in organizations. Each project will undergo some element of a privacy impact assessment, of course, assuming that it does that there is personally identifiable information involved, and I think that particular standard will be useful in that regard. So that's it. Thanks very much for your time. I think that was a 15-minute whistle-stop tour, and happy to take any questions.